Hopefully, we're now kicking off. This is a SICES talk, predominantly aimed at just considering FIDIC contracts. It's much of an overview of FIDIC. I need to confirm that all the participants, attendees, a copy of the slides will be provided after the talk. And if you want to watch me again late at night, you can do so on YouTube, the SICES YouTube channel. This will be uploaded onto that as well. So without further ado, we'll talk about FIDIC and NEC. Hopefully I can get this working. We've had a few IT problems. Right, my name's Andrew Rush. I'm the senior partner at Archor. My fellow colleague Carolyn Porter is a partner at Archor as well. We're doing this presentation. We're splitting it up so you don't get too bored of listening to me for too long. Archor is a niche construction law firm. Most of you would have had presentations from us before, so you probably know about us anyway. So we just specialize in construction law and nothing else for our sins. Right, final marketing slide. This is our full team at the moment. In fact, it's too short. You've had two join recently, but that's the team at Archor who can deal with all your construction needs should you need it. Right. We're going to talk about FIDIC, otherwise known as the Fédération Internationale des Ingénieurs Conseils. That is my French accent. I have not in any way resulted in a stereotype by picturing a French man with a beret and onions. It also means I'm just going to make sure I get it exactly right, the International Federation of Consulting Engineers in English. It's one of these contracts. It's the most widely used contract in the world, but it isn't necessarily, or certainly isn't the most widely used contract in the UK, but we are seeing it more than we used to, hence the reasons for the talk. And I think the reason we're seeing more than we used to is tends to be used where you've got an international party, be it the main contractor, be Turkish, German, whatever, or tends to be in sort of large energy projects where maybe the funder, maybe the developer is more comfortable or more used to using a FIDIC contract. And then what tends to happen is the main contract will be a FIDIC contract, and then it then flows downwards. So let's say we're looking at a subcontract for a party. Ultimately, they need to understand the FIDIC contract because that will be the contract that they mustn't put the main contractor in breach of. So even if you aren't actually being given a FIDIC contract, often your subcontract relates back to it. It is very much a sort of energy utilities related contract at the moment, at least in the UK. It's used all over the world for large infrastructure projects. Hinkley Point is stated to be based on FIDIC. I've not seen the Hinkley Point contract, but I assume it's somewhat heavily amended. But there's an example, and that no doubt is because the French, I'm trying to think who the French party is, Hinkley, the French electricity company, will be more comfortable using FIDIC. So what we're going to look at are the key principles behind FIDIC as compared to NEC, the different suites of contract that are available, and then Carolyn's going to look at sort of the vast bulk of the key differences. I'm just going to come in at the end and steal all the glory. So I think it's important to understand what FIDIC is, or where it sits compared to NEC. Now, most of the SICES members are very familiar, very on top of NEC contracts. So this is not an NEC talk, we're just using NEC as a comparator so you can see the difference between FIDIC and NEC. As I've said, you need to know because they are becoming more used or referred to in UK contracts. Now, there is a case, Murphy and Beckton Energy, where, the headline article was that Murphy didn't understand FIDIC. I'm not sure that's really fair if you look at the facts. Murphy had signed up to a FIDIC contract. Again, it's an energy, it's a power plant. They signed up to a FIDIC contract. The FIDIC contract had been amended such that a call on the bond did not need, effectively the bond had been turned to an on-demand bond. Murphy had understood the bond to be only payable, only had to pay LDs if the engineer had decided that they were late. So Murphy argued that the engineer hadn't made a decision, therefore no call on the bond could be made. Beckton Energy called on the bond anyway for £8 million, went to the High Court, and Beckton won because their amendments to the contract basically turned it into an on-demand bond. The headline is that, you know, Murphy doesn't understand FIDIC. That's not fair. But what it perhaps does reflect is, you know, a lack of familiarity with that contract led Murphy to read it one way, and maybe they should have read it the other way. I'm sure they didn't end up paying $8 million. I'm sure the deal was done. But the point was, that's what the court decision says. Now, the other thing to reflect on is that whichever contract you have, it essentially is doing the same thing. They're there to define who takes what risk. A contractor is paid a certain amount of money by the employer to carry out certain works. And all of the different contracts you will come across have pros and cons. The key is to understand those pros and cons so that you are, you know, better able to deal with any issues that arise and effectively don't lose money on them. So whichever contract you've got, it's just understanding the risk profile. Right, moving on to FIDIC itself. So the principles behind FIDIC, so this is very much an overview of FIDIC rather than, we are going to delve into some specific clauses, but it's important to understand the sort of overall basis. It's stated to be drafted by engineers experienced in construction. Whether that's good or bad, I don't know, but that's what it's stated to say. And it's stated to say it's a balanced risk and reward allocation. Now, in fairness, for example, if you take ground condition risk, which we'll come on to, there is a relatively fair, unforeseeable ground condition risk position. Now, this, of course, is before anyone's amended it. But if you ignore the amendments to it, it's a relatively fair risk-reward allocation. The key with FIDIC is the role of the engineer, or in the Silver Book, it's the employer's representative, but it's the role of the engineer. They are the project manager under NEC, they are the contract administrator or architect under JCT. And as is fairly obvious, the contract only works if that party does their job properly. The overriding aim is to increase clarity and reduce the risk of disputes. Those sort of things are said about NEC contracts. They're probably not said as much about JCT contracts, to be honest. And you know, you will see as you go along that FIDIC is probably most closely aligned with NEC. So the FIDIC suite comes in different colors. We like to do this in the construction. You have to give the names of colors to books because it makes it easier for us to remember. The clauses we're going to refer to today are from the Red Book. Now, the Red Book is called the Conditions of Contract for Construction. It's really a build-only contract, but as with all build-only contracts, it's not actually just a build-only contract because it also has a design portion part, which is why we're going to refer to that. The Silver Book is a turnkey form of contract. So that is a full design and build. It's drafted on that basis. It's very, well, it's more full design and build than JCT, for example, because it literally is the contractor takes all the risk. And then there's also one which actually I would argue is probably the one we see the most, the Yellow Book. That's conditions of contract for plant and design and build. So that's where you've got a sort of arguably a big tin shed with some very expensive plant inside. The equivalent to the Yellow Book would be IChemE contracts. There are other versions of FIDIC that exist. There's a specialist underground works contract. There's a small works contract, which is called the Green Book. There is actually a Pink Book, which is used where certain financial institutions are involved. So some of the provisions are, it's based on the Red Book, but more favourable to the financier. And then one you may be aware of is the old Gold Book, which is for use with design, build and operate contracts. So the old PFI schemes, which tend to be design, build and operate, the person who built it then operates it for a certain amount of time. That's what the Gold Book is for. Again, the ones we tend to see, I would suggest would be more Yellow or Silver Book, just because the UK prefers a sort of full D&B, but doesn't tend to go into the operations side as well. There are subcontracts. I'm going to come on to this, but one of the issues with subcontracts is there aren't subcontracts for everything. There is one for the Red Book, albeit it's only for use for the 1999 edition of the Red Book. The newer versions are 2022 editions. And there is a Yellow Book subcontract, even though it's produced in 2019, is still only stated to be used for the 1999 versions. So there is an issue that FIDIC don't put a lot of emphasis on subcontracts, which we'll come on to later. In summing this up, I would suggest that if you take a bit of JCT, a bit more of IChemE, and a bit more of NEC, you end up with a Red Book FIDIC or FIDIC contracts. And it's a combination of those three, but much less so JCT. It's much more aligned to NEC. And as we'll come on to, there's some provisions in IChemE contracts that are also reflected in FIDIC contracts. It's because they're civil engineering contracts. NEC is just whatever. I know it can be used for everything, but it is originally based on the ICE forms, or ICE produce it, civil engineers. IChemE tends to be more civil based as well, rather than pure building. So in summary, what you hopefully got from is that the choice of contract in FIDIC is based on the level of design risk. So the Red Book is minimal design risk, the Silver Book is full design risk, the Yellow Book is a function of the plant. It's not based on how you're paid. NEC, for example, option A is based on a fixed price, option C is target cost, option E is cost plus. So the NEC approach to which contract you use is based on the costing, whereas FIDIC is more akin to JCT and IChemE, which is based on the procurement approach. FIDIC has a range of testing provisions, which obviously, if it's energy related infrastructure, you need to test that. NEC and JCT don't readily have those provisions unless you put them in. IChemE, of course, does. So again, there's a similarity there with IChemE. The difference between FIDIC and NEC is that FIDIC is more akin to JCT when it comes to extensions of time and, or use the word loss and expense, but in FIDIC it's called costs. They are separate claims, whereas under NEC, of course, it's a compensation event that deals with both. It's mandatory to refer to disputes under FIDIC to the Dispute Resolution Board. There is no suggestion that it goes to the relevant jurisdiction, the relevant country. It's because it's international, they want to keep it consistent. There are certain countries where the legal system is not seen as particularly fair, so everything is referred back to arbitration. NEC can do that. JCT certainly as a default does not. And one really key clause with FIDIC, a bit like NEC's, the NEC 61.3 is mirrored in FIDIC 20.2. There are certain time limits you have to make claims, otherwise you lose your right. Albeit in a rather bizarre way, the Dispute Resolution Board can waive that if they see fit, but I wouldn't encourage that as an approach to adopt. So as I said, what drives the choice is the level of design. If you've got small or very complex, there is a book that exists. I mean, I think if we have to be realistic. The chance of the book being unamended is pretty slim in these jobs. And there are also some niche ones, but there are nowhere near as many options as there are for NEC. So just to summarize the difference, Red Book is most of the designs by the employer. There's a stated engineer. The Red Book is valued on a remeasurement basis as a classic old school sort of civils contract where the design's done by the client and it's a remeasurement contract. The Silver Book is much more akin to a sort of JCT D and B. So the contractor has full design responsibility. There's an employer's representative rather than the engineer, lump sum, full risk. And the Yellow Book is a bit of a halfway house, but it is essentially a full design and build contract, albeit the engineer is the third party there, and the contractor has to, it's a CPs, ERs type thing, whereas the Silver Book, the contractor's taking full risk. Final point on FIDIC is that the way it's put together is you have a main set of conditions. You then have the standard contract data approach that you'll find in NEC, and then there's a whole series of special conditions where there are sort of options pre-drawn. So a good example is unforeseeable physical conditions. In the unamended general conditions, a contractor is entitled to time and costs for unforeseeable physical conditions. We'll come on to that in a moment. But if the parties want to agree the share of that is 50-50 or whatever percentage, there is a pre-stated clause in the special conditions where you do that. And there's a whole host of these different clauses to effectively enable the parties to work out risk pots for various clauses. I'm not going to spend too long on NEC because everyone listening to this probably knows more about it than I do. The whole ethos behind NEC is for there to be proactive management. That is similar under FIDIC. The project manager's role is critical, the engineer's role is critical, so there are distinct similarities between the two. You'll all know the NEC comes in lots of different colours. You've got the option A, option B, remeasurement, fixed price, both fixed price but remeasurement, target cost, cost plus, and then you've got a much bigger suite of alternative contracts that FIDIC doesn't have. I think you've got to look at it that FIDIC is aimed at the really large projects. So the idea of them having short forms doesn't really sit comfortably with the whole purpose of using FIDIC. Again, a key difference is that NEC has pre-drawn subcontracts when FIDIC does not. So if you are subcontracting, then obviously that there's a bit more work to be done. Come on to that in a moment. And what drives the choice of NEC, as I've already explained, is it's the price that drives the choice. NEC is trying to be a contract that covers everything, so you have all the secondary options, W options, Y options, Z options. FIDIC is not trying to do that. FIDIC is very much a sort of almost the big daddy version. You just use the FIDIC as it is. And without further ado, I'll pass you over to Carolyn.
Thanks, Andrew, and good morning, everybody. I am going to talk to you this afternoon about the key differences that arise between NEC and FIDIC. So I'm going to run through design liability, subcontracting, which Andrew's touched upon briefly already, ground condition risks, claims, and conditions precedent, and then I will pass back to Andrew to finish by running through testing, termination, dispute resolution, and the potential problems with the Construction Act not necessarily being fully incorporated into FIDIC. So, firstly, I'm going to look at design liability. Now, as Andrew said, FIDIC wasn't necessarily drafted from an English law perspective, and as a result, parts of FIDIC are expressly contrary to a lot of common law English principles, and this can obviously cause problems when using FIDIC for UK projects. And one of those problems is fitness for purpose obligations. So the English law principles surrounding fitness for purpose stem from the case of IBA versus EMI and BIC. This case, I won't go into too much detail, but the case itself related to the construction of a TV mast on Emley Moor, and high winds and ice caused vortex shredding to occur, which resulted in the mast collapsing, as you can see from that picture on screen. In this case, the court distinguished between a contractor's level of skill and care as opposed to that of the designer. And the court effectively said that in the absence of any wording to the contrary, a contractor guarantees that the finished product is fit for purpose, and this includes any obligation that the contractor holds for design. So as a result of this, what has emerged is the somewhat bizarre situation where a contractor's duty of care for design is higher than that of a designer. And this is why it is important that any reference to the standard of care for design is to that of a designer and not of a contractor, so as to prevent any implied fitness for purpose obligations. So, there was another case following on from that, which is called the MT Hogard case. More recent, this related to the Robin Rig wind farm in Scotland. Unfortunately, the grouting to the foundations failed, and the cost of the repair was going to be in excess of £23 million. Now, in the contracts in this case, there were conflicting clauses. One clause said that the contractor was to use reasonable skill and care in carrying out the design, but there was also a provision tucked away in the specification saying that the foundations had to have a design life of 20 years, and there was an express contractual requirement that the contractor comply with the specification when completing the works. Now, the latter was determined by the courts, so the requirement for a design life of 20 years, as being a fitness for purpose obligation. And in this case, the court came to the conclusion that the two competing clauses, so the reasonable skill and care clause, but also the implied fitness for purpose obligation, of the two, the higher standard applied, and so a fitness for purpose obligation did exist in the contract. And therefore, Hogard was ordered to pay £23.6 million, despite the courts accepting that Hogard had exercised reasonable skill and care when completing the design. So why does this all really matter? Well, put simply, if you sign up to a fitness for purpose clause for design, it's very likely that this will not be covered by professional indemnity insurance. And there's just a standard extract put on the screen there by way of an example, and you'll see the exclusions refer to not being protected for any fitness for purpose obligations. And insurers, being insurers, would ordinarily argue that that would mean you would be uninsured, full stop, and you wouldn't be insured only up to the level of reasonable skill and care. So to make sure you don't fall foul of being outside any insurance policy, it's important to check that any reference to using reasonable skill and care for design is to that of a designer and not of a contractor. Be wary of any terms saying that works will be fit for purpose. At best, it should be limited only to materials being fit for purpose. Look out for any wording that says the works will comply with a performance specification. If this wording is included, you need to make sure that the specification is reviewed very carefully to avoid any Hogard situation arising. And also beware of collateral warranties that may have different level of skill and care to the main contract or potentially any professional appointment. Now, all right. Apologies. So what does this all have to do with FIDIC? Well, FIDIC expressly states that the works, when completed, shall be fit for purpose. So that clause will not be covered by most insurance policies. FIDIC also states that the design of the works will comply with a specification, which again potentially may result in a Hogard situation and again not be covered by insurance. Now, I appreciate this slide might not be the easiest to read, but I've copied two extracts there from the footnote commentary to emphasise the problem with the FIDIC clauses. And in case you can't see precisely what those clauses say, the commentary effectively confirms that FIDIC is well aware that the wording in the standard clauses may cause problems in certain jurisdictions, resulting in an inability to obtain PI cover. And FIDIC also recognises that this is the case even for design professionals, but it goes on to confirm that by saying this, it does not relieve the contractor from its obligations, and therefore the contractor still has to accept the risk. Now, obviously, invalid insurance will often be wholly unacceptable, often on funded projects. And so if you're using FIDIC for UK projects, these clauses will need to be expressly amended. Moving on then to NEC. NEC doesn't place an express fitness for purpose obligations onto contractors. However, this can potentially be implied by the scope, because clause 21.1 of NEC states that contractor is to design the works of which the scope states the contractor is to design. So subject to what is in that scope, there's potential for Hogarth situation to be implied. NEC does, however, give the parties the right to limit the contractor's design liability by using option X15, and I've copied the key clause X15.1 onto the slide there. This limits the design liability of the contractor to that of reasonable skill and care of a designer, which, as I previously said, it sounds wrong, but that is what you need to prevent fitness for purpose from being implied. We'd always recommend, therefore, to contractors when using NEC that X15 is adopted. If in doubt, as I said, FIDIC will need to be expressly amended, but if you're unsure as to any of the specific amendments within any clause that you're given, it's not uncommon now to see the following wording added to all UK contracts, just to ensure that the contractor's liability for design shall not extend to one for fitness for purpose, and therefore insurances are effectively in place. Moving on, therefore, to subcontracting. So, as Andrew said, interestingly, FIDIC does not have a set of subcontracts to go with each main contract. FIDIC also does not have an up-to-date set of subcontracts. Instead, there are only two forms of subcontract, red and yellow, and both are designed for use with the 1999 main contract books. And that's despite there being a more recent version of the yellow book before the subcontract was even published. This brings with it certain obvious problems, given the numerous changes that have occurred under English law in the last 25 years. As a result of this, whilst both subcontracts attempt to pass down the risk on a back-to-back basis, there are significant problems with the standard forms, including various non-compliances with the Construction Act, which Andrew will touch on shortly. Probably the most shocking of those examples are that there's an express clause within the yellow subcontract permitting pay when paid arrangements. So there are a few points in the FIDIC main contracts which relate to conditions over subcontracting, but there's nothing particularly substantial. The Red Book does provide that a contractor is not permitted to subcontract the whole of the works and must obtain consent to subcontract any part of the works. The Red Book also provides for nominated subcontractors to be used in certain instances. Those nominated subcontractors remain at the main contractor's risk. They must enter into a back-to-back subcontract which indemnifies the main contractor for breach, and the main contractor does have a reasonable right to object to using those nominated subcontractors. The Silver Book has no restriction at all on subcontracting, but that simply reflects the nature of the book being the turnkey book and reflects less employer involvement. NEC is different to FIDIC in that there is no express ban on subcontracting all of the works. However, the project manager still has to consent to the proposed subcontractor and the subcontract form. Otherwise, NEC is relatively silent on subcontracting, but there is, of course, a full up-to-date suite of NEC subcontracts which are aligned with the suite of main contracts, and obviously that then makes it easier to procure an entire project under NEC. So, is subcontracting under FIDIC a real problem? Due to the fact that FIDIC doesn't have a full suite and it doesn't have any up-to-date subcontracts, it can potentially create problems in establishing a back-to-back chain of liability in projects. There's seemingly no reason why the full suite doesn't exist, but it's probably due to the fact that FIDIC is used across so many countries that it's not necessarily possible to produce a one-size-fits-all subcontract. However, the same could, of course, be said for the main contract suites. The result of this is that main contractors often use their own bespoke subcontracts, but this is obviously not without its own risks. Moving on then to physical conditions, which are often referred to as ground risk clauses. So under FIDIC, the starting point is that the Red Book, which is of course the more akin to a contractor design portion contract, allows the contractor to claim time and money if unforeseeable conditions arise. And unforeseeable is defined by what would be deemed to be unforeseeable by an experienced contractor at the base date. The Silver Book, which is the full turnkey book, puts the risk of all physical conditions onto the contractor. NEC contracts deal with responsibility for physical conditions by sharing the risk between the parties, with the contractor being entitled to a compensation event, which is clause 61, where unforeseen physical conditions are discovered on site which cause a delay or extra costs. Clause 60.2 then sets out that this risk is shared on the basis that the contractor accepts the risk for site conditions that they should have taken into account based on the information provided by the client and information that is readily available. The client then takes the risk on any other site conditions. So what are the key differences in approach? On first glance, the approach in NEC appears very similar to the approach in the FIDIC Red Book, but there are some discrete differences. When assessing whether the contractor has accepted such a risk, FIDIC takes more of a subjective approach of assessing whether something or not was foreseeable, whereas NEC is more objective in its approach because it actually refers to a set of criteria which a contractor is deemed to have taken into account when assessing whether or not they should have been aware of it. Secondly, the impact of accepting or not accepting such a risk differs under the contract forms. So under FIDIC, if the physical conditions are found to be unforeseeable, the contractor is entitled to its costs but not profit. Under NEC, unforeseen physical conditions are a compensation event which entitles the contractor to recover its costs plus the fee, which is ordinarily meant to cover the overheads and profit. Moving on then to claims under both forms of the contract, predominantly time and money claims. So FIDIC approaches contractor claims in a similar way to JCT, in that if a certain delay event occurs, the contractor gets the right to an extension of time, and then a separate right to costs arises, either with or without profit on those costs, depending on whether or not the delay event was caused by the employer or whether it was a neutral event. NEC, as I'm sure you all know, deal with delay and costs under the umbrella of compensation events. So under FIDIC, a contractor's right to an extension of time is set out in clause 8.5. This clause sets out the delay events that give rise to an extension of time. And of interest is subclause D, whereby the contractor can get an extension of time if there's a delay caused by labour or material shortages, caused by an epidemic or government actions. So this clause would undoubtedly assist during a COVID type situation, and it's not a clause often found in standard form contracts. For cost claims under FIDIC, A claim may arise if the contractor considers it has an entitlement to any additional payment from the employer, which is a very wide provision. FIDIC contains condition precedent clauses in relation to notifying of claims. I will touch on condition precedent clauses in more detail shortly, but for the purpose of this section of the talk, the key point to note is that contractors must provide notice of the claim within 28 days of becoming aware of such a claim. And this is key because the contractor will lose its right to a claim if not complied with. And thereafter, the contractor must provide a fully detailed claim within 84 days of becoming aware. Now, under NEC, what constitutes a compensation event is set out at clause 60.1. I won't list all of them, but this includes, some of them are shown on the slide. It includes a wide range of issues designed to capture all potential employer risks under the contract. Now, there are two ways of notifying a compensation event under an NEC contract. Firstly, if an instruction is issued by a project manager, that instruction in itself is deemed to be notification of a compensation event, and that's shown on the slide under 61.1. For all other compensation events, the contractor needs to notify the project manager within 8 weeks of becoming aware. Otherwise, the contractor again loses its right to claim the compensation event. Now, when assessing compensation events under NEC, the change to prices, which arise as a result of the compensation event, are assessed as the actual cost incurred up to the dividing date and the forecast cost after the dividing date, plus the fee, which includes profit. And the dividing date is the date the notification of the compensation event was made. Changes to the completion date then are assessed as the difference between the planned completion on the accepted programme current at the dividing date. Again, it's the same dividing dates being the date of notification, and the actual planned completion date as a result of the compensation event. And when assessing the impact, only the operations which are incomplete and which are impacted by the compensation event are changed. Moving on to concurrent delay, English common law principles provide that where concurrent delay occurs, and by concurrent delay I mean two simultaneous delay events, one which gives rise to an extension of time and one which is a contractor's risk event. The contractor gets time but no money. So a contractor would essentially be entitled to an extension of time but not to recover the costs of that delay. However, this can be amended in any contract, so it's always imperative to check what any given contract says in this regard. FIDIC states that where concurrent delay occurs, the contractor's entitlement to an extension of time should be assessed in accordance with the rules in the special provisions. Now, as Andrew mentioned before, the special provisions are effectively to be completed by the parties when entering into the contract, and they propose different ways that certain clauses can be amended to change the risk profile of the contract. It's therefore critical to set out in the special provisions that a contractor can get an extension of time if concurrent delay occurs. Now, the fact that this is set out in the special provisions can be seen as useful by some because it brings the issue to the forefront of the parties' minds at the point at which they're entering into contract. But equally, in the absence of any wording on this issue, the English law position assists the contractor. So it may actually end up in FIDIC resulting in some bad bargains being entered into on the part of contractors. Concurrent delay under NEC is somewhat of a legal conundrum. NEC is entirely silent on concurrent delay, and this is likely because concurrent delay arguably never arises under NEC. And that is because of the way NEC approaches compensation events. So each compensation event is intended to be plotted separately against the latest accepted programme at the point in time at which it occurred. And so each compensation event is intended to be treated entirely separately, and therefore in theory concurrent delay arguments should never arise. However, in practice it's still an argument that does come up relatively frequently, with parties trying to argue various means of getting around this. Keating notes on the topic that the approach under NEC is still subject to a fair and reasonable outcome, so that the way that NEC is implemented results in a fair outcome. And then moving on to conditions precedent. So this is the last point I'm going to touch on. As I previously noted, both FIDIC and NEC contain express conditions precedent in their unamended forms, and so it's important to understand what this means. Condition precedent clause is effectively any clause which requires an action to be undertaken by a given party within a specified period, and the clause must also state that a party will lose a contractual right if they fail to comply with the condition precedent. Condition precedent clauses might cover payment variations, and the key ones that we often see are extensions of time and loss and expense. So an example of a condition precedent clause might be, as we saw in the NEC, contractor has to notify of a compensation event within 8 weeks of it occurring, otherwise it will not be assessed as a compensation event. All claims under FIDIC are subject to a condition precedent clause, as can be seen in clause 20.2 on the slide. And this requires the contractor to give notice of any claim within 28 days of becoming aware. And English law has become increasingly strict on the enforcement of condition precedent clauses in recent years, and failure to comply with this clause would likely be a bar to any claim. NEC also contains express condition precedent clauses, as we saw previously. On the slide here, we have the standard clause 61.3, and I've shown some common amendments in red. This clause in NEC is often amended to reduce the notification period. So here you can see a contractor now only has 4 weeks to notify of being aware of the event, but also to place a requirement on the contractor to notify of all compensation events, even project manager instructions. Now under the standard form, as I noted before, a project manager instruction would be a notification in its own right, but as you can see here, that has been deleted, and therefore there would be an obligation on the contractor to notify that it considered any given instruction to be a compensation event in order to rely on the same. And again, these clauses are enforceable in English law, so it's imperative that contractors know what conditions precedent exist in any given contract, and that contractors comply with the same in a timely manner. So that's about it from me. I'm now going to pass back to Andrew, who will run through the final key differences.
Right, and Carolyn can now check all your questions, and if there are any difficult ones, she's going to ask me them. I've got just a couple of minutes, and then we'll go on to questions. So, just want to briefly touch on a few other things. FIDIC, as I explained earlier, has a testing regime of takeover tests, pre-completion tests, very similar to ICME, in that there is an expectation there'll be a plant or machinery that will be involved that needs to be tested. JCT and NEC don't really have that sort of wording, and it's probably something they need to deal with going forward. One difference between FIDIC and ICME is if the performance tests are not achieved, there's no clear performance damages under FIDIC, whereas under ICME, if you don't achieve the performance, then you pay performance damages as well as delay damages. So again, ICME is much more focused on the plant, FIDIC's a halfway house, and NEC and JCT perhaps need to recognise that plant is now a key part. So just to make it clear that testing is in there. And one of the things I would say is even if you're using a JCT or an NEC, it's not unhelpful to refer to ICHEME or FIDIC wording if you need to put in testing clauses, or more importantly, if you ask us as your lawyer to put them in. Termination. Now, FIDIC has a termination at will clause. It does sit alongside the right for the contractor to have loss of profit. So again, in almost, I'm sure that will be varied, but FIDIC allows a termination at will clause, whereas NEC, which I'll come on to, doesn't. But it does sit alongside a loss of profit clause. So in the event a client did do that, then the contractor would be entitled to loss of profit. FIDIC has a right, or does not have a right to omit work and allow others to do it. So in other words, there is no express right to take work away and give it to a third party. Now that reflects, as it turns out, in use common law, because if you do that, that's a repudiatory breach. But it's interesting that FIDIC has an express prohibition on removing work and giving it to a third party. NEC, as I said, does not have a termination at will clause. It has a very convoluted set of possible termination bases, payment structure depending on which termination has occurred. You can omit work, which you can do under FIDIC, but you can't omit work and give it to a third party. FIDIC makes that clear. NEC doesn't make it clear, but if you do that, you will be in repudiatory breach. So wise not to. Dispute resolution is an interesting area in FIDIC, is that there is no adjudication clause because it's an international contract used all over the place, and therefore not all jurisdictions have adjudication, albeit increasingly English law jurisdictions are adopting adjudication. FIDIC default is arbitration via a dispute advisory board, or if that doesn't work, an arbitration. NEC, often you have to go to adjudication first unless it's changed, and then there's a choice of tribunal. The default is typically arbitration, but parties can choose either. But there's no opportunity under FIDIC to use the local court. Now, the issue with adjudication not being in a FIDIC contract is, to a certain extent, a bit of a red herring, because if the work is done in the UK, you will be governed by adjudication, because adjudication is a function of where the work is carried out, not what is stated to be in the contract. So if the parties remove or don't include adjudication, it will still be implied anyway if the work is carried out in the UK. It gets a bit complicated when it's carried out beyond 12 miles from the UK coast, as to whether that's the UK or not. But if it's on hard ground, then it will be covered by adjudication anyway. Finally, I don't know, this is a sort of quiz question. Anyone knows who that person is? That person is Carolyn. Sir Michael Latham, who's no longer with us, but he came up with the Construction Act. Everyone's going to be nice to each other. Whether that's worked or not is another matter. But FIDIC does not have the standard sort of clauses you would need in a UK contract, and because if the work is carried out in the UK, it's covered by the Construction Act. So payment notices, payless notices are not there. No right to suspension for non-payment. Does have pay when paid clauses and no right to adjudication. So if you are using this in a UK context, those sort of provisions need to be fixed. I've said it already, and I'll say it again. A lot of the FIDIC contracts you'll see are heavily amended because of the nature of the work involved, but there is, the basic principle is there. Right, we've got about 6 or 7 minutes for questions. I've got some. I don't know if Carolyn's managed to dig up any from the list, but you can fire away and
Yeah, so let's run through these. So noting that adjudication is not specifically included, if most of the projects are related to power stations, aren't they excluded by the power generation exception?
Well, that's a sensible question. And I suppose to the extent the work is carried out in the UK, but is carried out in relation to power generation, then 105.2c excludes those contracts. However, and those of you who are lovers of adjudication will know it's not quite as simple as that, because it's subcontracts that do not directly relate to power generation will still be covered by adjudication. It's only if the actual work itself is directly related to power generation. So, for example, if you put a road in on a site where there's power generation, that will be covered by adjudication, even though the underlying purpose of it is to get you to the power station.
Okay. How does FIDIC compare to a logic contract?
Okay. I'll be honest, I haven't read many logic contracts. They are used in the oil, gas industry. I think that's what it stands for, oil and gas industry. Logic contracts, to my understanding, when I have in the past, I'm quite old, had to refer to one. They tend to be very turnkey, full risk contracts. So they're not dissimilar to the Silver Book. But I have to say, I wouldn't be able to give a full answer on the distinct differences between the two.
Why are there no UK-based set of amendments for FIDIC?
That's another good question. And I think, well, the obvious reason is that FIDIC sees itself as international and doesn't see itself as focused on the UK, but that's slightly at odds with the fact that often English law, English arbitration will be used. I think if there was a set of amendments for FIDIC used in the UK, it may be more popular, because FIDIC does seem to me to be a relatively good compromise between NEC, ICME and JCT. So without that, it does require more work. So yeah, it's not.
Okay, and then the last one, is it recommended to have, in a contract based on FIDIC's electrical and mechanical works contract, an external expert acting as the engineer? Or is there no problem in recruiting the engineer from amongst the beneficiary, in our case, public authority? Goes on to say, we are signing a contract shortly. The engineer is, according to the Red Book, bound to act impartially. Is there any incompatibility in the relationship to his employer?
Well, this is a more general question. I think I've seen that on the FIDIC website. I think it's a more general question that can you have a sort of non-independent third party? And ICI and Merit's probably a good example of why you probably shouldn't do it. By having your own internal engineer, whilst they theoretically can act impartially, it's very difficult to. And there are a whole host of cases starting from Merton and Leach through to the Eurotunnel, I think it's Bechtel, I think, where the project manager, employer's agent, whatever it might be, if they are an internal person, it becomes very difficult to sort of accept this, and courts find it very difficult. So the truth is, if you want to ensure the contract works properly, you need an external third party rather than one from an internal organisation. And that, to be quite honest, that applies to FIDIC, JCT, NEC. There was one final point that I did think of when Carolyn was talking about nominated subcontractors. They're much clearer in FIDIC as being something that you are more likely to use. But ironically, FIDIC then turns it on its head and says you're much more likely to be nominated subcontractors, but makes it expressly clear that the way we'd understand it, at least, they are treated as domestic. Whereas JCT can be, there are arguments about what happens if they go into insolvency and stuff. FIDIC, whilst perhaps using nominated subcontractors more, still makes it abundantly clear that's a full contractor risk.
One final one has just come through. Is priority of documents a feature in NEC similar to FIDIC?
That's a good question. Does NEC have a priority of documents?
I don't think it's an express clause.
I don't think it does. I think FIDIC does. But what I can do is, off the top of my head, I will just drop a note to Heather who can answer that. But again, the issue of priorities of documents is, and as you'll all know, irrespective of what standard form says, almost always that is amended such that the agreement, the conditions, etc., take precedence over the technical documents, and then they'll tend to be an order of precedence. Subcontracts tend to use numbered documents, etc. So whilst the standard form may say one thing, the amended forms almost invariably will give a very distinct hierarchy of priority. But I will expressly answer that in a moment.
And that's everything.
Okay, we'll think we'll call it a day. We've got 2 minutes to go, so thank you all very much for joining. Heather will switch us off in a moment. As I've said already, the slides will be sent if you want a copy, and you can, if you are mad enough, watch this again on YouTube. So without further ado, we'll say goodbye.
Thank you.